Court does call the case of the people versus Brendan Williams.
Brendan Williams, who is present via Zoom. Unmute, state your name for the call.
Brendan Williams.
Garner, Miss Lonnie Feltus did provide a plea form regarding this case that I believe that will be entered. However, I need to have my client review that and discuss it with him. I would request 2 things for a brief adjournment, and then also Mr. Williams, if you could possibly update your phone number, you can have it my text. I believe your voicemail box is not set up yet either. So thank you so much, sir. Thank you, Your Honor.
This case may sound routine at first, but don't let the calm courtroom tone fool you. What begins as a simple embezzlement charge quickly turns into a textbook example of how even small financial crimes can carry serious legal consequences. We're looking at an employee accused of abusing trust, manipulating workplace systems, and personally benefiting from money that was never his to take. The court is methodical here, no drama yet, but every question, every confirmation is building toward an irreversible legal moment. Guilty pleas aren't just admissions, they're the surrender of fundamental rights. And once that door closes, there's no easy way back. Stay with us, because what happens next shows how quickly accountability replaces excuses.
All right. Thank you. November 19th, 2025, 9 a.m. I'm continuing. For a cause case, people versus Brennan Wilson.
Good afternoon, this is Paul Quinn on behalf of Mr. Wilson. Mr. Wilson, state your name for the record.
Brennan Wilson.
Is your last name spelled with 2 L's?
Correct, yes.
Okay, very good. All right. I have before me a plea form that indicates that the defendant will be pleading guilty to count 2, embezzlement under 200, the 93-day offense. Upon this successful plea to that charge, count 1 would be dismissed. Defendant is also agreeing to make restitution as ordered by probation. And also the prosecutor and defendant agreed that people do consent to HIDA.
That's all correct, Your Honor. That is correct.
All right. Mr. Wilson, can you raise your right hand, please, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name again for the record, please.
Brennan Wilson.
Okay, you can put your hand down. Sir, it is this court's understanding that you're going to plead guilty to the charge of embezzlement by an agent or trustee under $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property which is taken or the subject matter of the embezzlement. If that's greater than $500, that would become the maximum fine. You understand that, sir?
This is where the legal gravity truly sets in. The judge carefully explains the consequences of a misdemeanor embezzlement charge, up to 93 days in jail, fines, court costs, and even enhanced penalties depending on the value involved. Notice how the court ensures the defendant fully understands every consequence before moving forward. This isn't intimidation, it's due process. The law demands that a guilty plea be knowing, intelligent, and voluntary. Once the defendant says yes here, he is effectively waiving his right to trial, to confront witnesses, and even to appeal most issues later on. This moment separates uncertainty from certainty and legally locks in responsibility. Ask yourself, would you still plead guilty knowing how permanent this decision really is?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty that you'll not have a trial of any kind?
Yes, sir.
Hang on. You signed an advice of rights form, is that correct?
Correct.
Any question regarding any of those rights?
No, sir.
Please, you understand that you're giving up all the rights that are contained on that form, inclusive of those rights contained in paragraph 5, which are your trial rights.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily,
Yes, sir.
of your own free will,
Yes, sir.
and because you believe that you're guilty of this offense?
Yes, sir.
May 21st, 2025, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. Were you an employee at Meyer?
Yes, I was.
And what'd you do that makes you think that you're guilty?
I wrote myself $200 worth of bottle slips that I shouldn't have.
All right. And this was money that the ultimate goal of this is that you were going to take money that belonged to the principal, that being your employer, Meyer,
Yes, sir.
and you didn't have their consent to do that.
No, sir.
And you were able to do this by virtue of the fact that you were employed as a Meyer employee, correct?
What makes this case especially important isn't the dollar amount, it's the breach of trust. The defendant admits he used his position as an employee to generate fraudulent bottle slips for personal gain. That's not a mistake, that's exploitation of access. Courts take this very seriously because employment-based crimes undermine institutional integrity. Employers rely on trust, not constant surveillance. When that trust is broken, the law steps in firmly. Notice how the judge establishes intent, lack of consent, and abuse of position. These are the pillars of embezzlement. This isn't about desperation or confusion, it's about knowingly crossing a line. And once intent is established, leniency becomes far less likely.
Correct.
All right. Sir, I do have to advise you that if I accept your plea between the time of my acceptance of your plea and the time of sentencing, that you commit misconduct as defined under the Michigan court rule, that you would not be entitled to any sentence evaluation and or recommendation. The court would not be bound by that, and you would not be entitled to withdraw your plea. You understand that?
Yes, I understand.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied. Satisfied, Judge.
All right. Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant's referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be December 10th, 2025, 9 a.m., or as your invite indicates. All right, sir?
All right, thank you.
Bond will continue. Sir, I need you to wait online. I'm going to put you into a breakout room with our probation department so we can begin the sentencing process. Okay, sir?
Okay, thank you.
Thank you. Court calls case People versus Summer Bell.
Defendant for on behalf of the object.
Public defender Natalie gave me permission to accept the offer.
And Your Honor, I'm going to move that count 2 double plea. You accept that admission and dismiss the official charge.
And Ms. Pate, on behalf of your client, do you bear responsibility to the fact that on July 4th, 2025, Ellsworth Road in Pittsfield Township, Washtenaw County, State of Michigan, is parked a motor vehicle?
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $180. When can she pay it?
Your Honor, she's asking for 60 days. She did advise to me that she is currently 34 weeks pregnant as well. And so she originally asked for 30. She really honest. I really miss it.
So hold it. The way I count that, that's so if I give 60 days, she's going to be in the throes of labor.
I know. I wondered if maybe like there's a lottery or something she's winning when her child is born. I don't know.
What?
I don't know.
I wasn't going there. I was just doing the math. And okay.
She asked for 60, Your Honor. That's
So she's due sometime in December, January. That's probably, well, earlier than that. Miss Perroney's going to speak to us as an expert. Everybody pause. Miss Perroney.
I think she deserves a big pot of money when she gives birth, but that's, that has nothing to do with my situation or my life. I can
A whole unbiased analysis.
Say about the very communicative. I didn't even have her phone number, like from arraignment, but she called our office, super nice to me. So I would ask these days of her behalf.
There's no way I can look at this at all. I'm just saying. I accept it. February 28, 2000.